Okay. Go!
You hand me my screen box? Now go. Freak. Rah.
Hey, District Court for County Washington, State of Michigan is now back in session.
May be seated. Court does call the case of the people, listen to me. Alec Jerome versus Eric Cassidy. State your appearances, please.
Yes, I'm Donna Tope. I'm the agent and attorney for Alec Jerome and Caroline Jerome, who are brother and sister owners and landlords for the premises at 3270 North Maple, which is the subject of this landlord-tenant case.
Good morning, Your Honor. Francine O'Rourke appearing. Good afternoon. Francine O'Rourke appearing by and with the defendant. I would note for the court that Paula Cassidy, who signed the lease agreement in this matter, is also present. We believe she's a necessary party, or at least permissive, and we're going to ask the court when Your Honor is ready for us to get to that point to join her as a party.
Well, why she signed the leasing agreement, right? So why isn't she we can deal with that right now. Why isn't she a party?
She was at the beginning of this. This is not the first time we've been here. And we have in our clause, we have a joint and several liability in our lease. We have a joint and several liability clause, which allows the landlord to hold each signer of the lease, each tenant, to be held individually responsible. Mr. Cassidy gave us notice early on that he did not wish us to involve Paula. And while we sent her everything.
Okay, so can I just say this? Are they both residing at the premises?
Yes.
Okay, so this is a non-payment of rent case.
Yes.
Okay. So, assuming that you prevail and the judgment is then entered and your remedy under the judgment is to evict, how would you intend upon doing that? Well,
if we go forward and this case is allowed to be as it should be against Mr. Cassidy, and he is ordered to pay and he doesn't pay, we would evict him. And we would then...
But seriously, I okay. Hear you, but from a practical standpoint, how are you going to do that? Because as the landlord, you would be required to not only have him, you would no longer be able to give him access to the property. I don't know how you would then present that or prevent him from then having access to the property. And you would have to remove all of his items from the premise.
That's a practical matter that would be worked out. However, Your Honor.
No, it's not a practical matter. You won't get a red. I have, for 20 some odd years, I will not sign a red because if I can't, I have at the end of the case, if the landlord prevails, I have to, my order is that the sheriff or court officer restore the premises to the landlord. That is on the order. You can't do that if you're only doing you're only doing one person in a...
As we go through this process, which in your 27 years of experience, you know, is very lengthy and lots of delays take place. If Mr. Cassidy doesn't pay the amount that we are asking for, we would then process and join Mrs. Cassidy, Paula Cassidy. But we're not at that point yet.
Join her in what?
Well, we would serve a notice. We would, start proceedings against her because she has not paid the rent either. But But from the beginning, Mr.
Okay.
Cassidy has been the
In my
one who
27
said
years,
not
but it's actually been
involved.
a whole lot more than that. That's just silly. Because what would end up happening is his judgment will be there. Then by the time you begin the other case, your 56 days is going to expire. So you're going to have a hearing to evict him from the premise. I mean, it just, that makes no sense to me.
Okay.
It really doesn't. I mean,
I of all things, I want to make sense to you. I mean, that would be my goal here.
Okay.
So,
well, folks,
one of the reasons that we did not involve Paula was we learned from Mr. Cassidy, he asked us to not involve her early on. And because she has suffered severe medical issues. And we sort of felt like that should be taken into consideration. And since he was the one that did all of the paying, all of the, interaction, we would leave her out of it and try to not make her situation any worse than it already was. We do not object to her joining if that's what they want to do, but that's not what he said he wanted to have happen.
Okay.
Since we're on the issue of parties, the plaintiff is also not really the proper party. The contract is between Cambridge Family Holdings, LLC, and my client and his wife, and the plaintiffs are Alec and Caroline individually.
They signed the lease. They're the owners of the property. I am their agent. I manage the lease. I manage the property, and I am their attorney.
Who is the landlord? Cambridge Holdings, LLC. Family Holdings, LLC.
Cambridge Family Holdings, LLC manages the property. That's the management company. That is my company, and you make the payments to Cambridge because we manage the property. We collect the rents.
Your Honor, the lease says the landlord, Cambridge Family Holdings, LLC. So
I see it.
Add them.
Can we go back to the defendant? The notice, I appreciate what you said regarding why you may not have involved Paula. And maybe I'm making an assumption. Eric and Paula, they're married?
Yes.
So one of the first questions regarding the defendants is, while the lease is joint and several in terms of certain liabilities, the interest in the property is really by the entirety. So I'm not even clear that you could split it.
Under the terms of the lease?
They're married, so their interest in the tenancy, the leasehold estate, is going to be by the entires. And it's indivisible. Certainly there are obligations under the lease. You might do a joint and several, like in terms of who's paying what, who's doing whatever. But I don't think you can proceed in that fashion, because their leasehold interest is indivisible from one another.
Are you proposing that we agree to join Paula in this? I have no problem with that. I just was trying to not be the bad person in this whole thing.
Counsel, what are you proposing?
The court rules do allow, well, actually what we're proposing is we'd like to enforce the mediation provision in the lease and ask the court to require the parties to go to mediation regarding this issue. The court court rules do allow the court sua sponte actually to add a necessary party that wasn't.
But I don't have jurisdiction over that party.
I think you would have jurisdiction over her.
I don't have subject matter jurisdiction over her interest in the property.
I read the court rule that if she's a necessary party and she agrees.
Oh, I know that. However, hey, folks, hold on a minute, okay? I receive subject matter jurisdiction over the interest in the tenancy by the serving of a notice because I'm a statutory court. There's no notice to her.
I did file a notice on the first go round, and that notice has not expired, and that was on both Paula and
Which
Eric.
one is in my file?
This is the second go round. Judge Barr dismissed that because the defendant, Eric, said that he had paid the rent, and Paula's attorney, Mr. Douglas, repeated that they had paid the rent, but they had not paid the rent. And the judge asked them, did they pay the rent? They both said yes. I said they have not paid the rent. And the judge dismissed the case instead of adjourning it to see if the rent had been paid. It had partially paid, but 15 minutes before the hearing started.
Your Honor, that case was dismissed because it was filed in the wrong venue, I believe, initially. I wasn't.
No, it was not dismissed because of that.
If the case was dismissed, the notice would no longer be applicable.
I don't know if that's true or not, because okay, so folks, I think, unless you want to show me something different, that their tenancy is indivisible. And so I have to have both parties. I can't split it. I can't split their tenancy. I don't even know how I would on one person, one party of a married couple's tenancy. I don't know how I do that.
Okay. I filed a third notice on all persons living at 3270 North Maple Drive. And it was dated March 7th, and they were told to move by March 15th. And I actually.
So this one just came up?
Pardon me? I didn't hear.
Well,
this.
Was this? Oh, the notice. Hang on a moment. The notice that I have in the file is to Eric.
Yes. If you look on that notice, you will see that it is dated February 4th, and they must move by February 13th. We had the hearing before Judge Barr, and he dismissed it. Then we filed here, and I used that notice plus this notice. I didn't include it in the file because it was sent from the other court to you.
What was
after the first hearing? This right now, what you have is what was sent from Judge Barr. And I have the notice here if I would be permitted to submit it.
When did that notice come into play? When was that notice served?
Yes.
So why isn't that the notice that I have in this file?
Because it wasn't part of what we filed with Judge Barr, and it took.
Okay, so let's get Judge Barr and Judge Simpson straight.
Pardon me? I'm having a hard time here.
Judge Barr and Judge Simpson, let's get that straight. We're the same court.
Yes, you are.
Okay. So, Judge Barr, just let me figure something out.
Thank you. Thank you. Great.
Is that better for you? Okay.
While you're figuring it out, I just wanted to let you know my client reminded me that the last case, which I wasn't part of, was dismissed because lack of proper notice was not given. Notice was not given.
This case that was heard by Judge Barr and transferred to you for the second hearing was filed with the proper court. He had the first hearing, but the notice that is in that case and this second notice were part of the same notice, because after I filed the complaint, I realized that there were other people living in the home that were not on the lease and had not been given permission by the owners or the landlord or me to live there. And I had a sheriff accompany me to file this second notice. And nobody would answer the door. There were people in there who were not the tenants. And he had...
Okay. All that's fine and dandy. All I'm trying to figure out is folks, let me just give you a primer on landlord tenant. What gives this court jurisdiction is a valid notice. That valid notice has to be with the court. The notice I have has Eric. That is it. You're talking about another notice. I don't know where this other notice is coming from.
May I make a motion or a request? One or the other. My motion would be for you to accept as evidence for this case the second notice to quit to all persons living at 3270, which was dated March 7th and was not available to file with this case. This is
it wasn't available. It wasn't available. Why?
Because there were a couple of situations that happened. As I said, I had the sheriff accompany me to the property. The people inside were not the tenants. They would not answer the door. So I couldn't serve the notice. We left it, but the only place to leave it was underneath the door. The officer told me that probably could get blown away and there would be no notice, and advised me to serve it again. About 4 days later, I did. I went up to the door.
Why didn't you just mail it? It's a notice to quit. Are you talking about the notice to quit, or are you talking about the
notice to quit to recover possession of property for non-payment of rent? Yes, I did mail it. I did go to tape it to the front door. Mr. Cassidy prevented me from being able to do that. I have it here, and I would like to ask the court's permission to have it included in this file so that we can move forward or adjourn until we can properly get it into before you. However that can happen.
Your Honor, I would oppose that and ask the court to dismiss the case at this point.
Oh my gosh.
Proof of service. Apparently, somebody went to my client's property at 10 p.m. at night when his wife was the only person in the home, trying to serve some documents on them. Nobody else was in the home. That was brought to the home apparently on March 7th. but this suit was filed before that. So that notice has nothing to do with this current lawsuit, which does not include the property parties. So at this point,
oh my God.
I would agree with the court. You do not have subject matter jurisdiction over Mrs. Paula Cassidy, who has a right to the property. Now I'd ask the court to dismiss the matter.
Well, I don't know that I'm going to dismiss it because, I mean, at least at this juncture, because I have a party that I have jurisdiction over in the property. I don't know what remedies from that can come because the ultimate remedy is eviction from the premises. But as this case sits now, I don't know that I could order an eviction from the premises because if it came to that, I just don't know that I could.
And that is my point. I don't think that you can make a decision about the end point until we have gotten through case evaluation. They're asking to have it sent to mediation. It could be that we won't get to that end point where you would not be in a position to order eviction.
So you want me to go through the whole process of a case and then not be able to impose a remedy? That makes sense.
I think that knowing that that's at the end of the line is motivation to not go to the end of the line.
Man, and let me tell you this. The problem is that I'm not even sure as to how this case proceeds without that other party. I mean, I don't know on some because I've got jurisdiction over somebody, but I just think this is going to be. I mean, I'll just sit here and make my rulings. I mean, I don't know what you guys want me to do because I'm trying to point out the difficulties here.
Eric is a legitimate party.
I agree.
They have asked to join Paul. If we agree or not agree, and you give them that, you grant them that motion, then I don't think you have a problem.
Except that she never got notice. Not that I have. I mean, you keep referencing a document.
Yes.
But
no. Yeah. In the first case that was dismissed, she and Eric both got notice. So they have known all along that this is coming down. And if
I know, I get that.
Okay.
But what I'm saying is I have to have a notice in the file. That's what gives me the ability to act. I don't have a notice regarding Paula Cassidy in my file.
And their request is to ask you to join Paula Cassidy.
I heard them.
And if she says, I accept that I knew that this was going to happen.
You read the summary proceeding statutes.
Yeah. But I know that judges have a lot of discretion in order to move cases along under equity. I have a
lot of discretion, and this one's
under equity
too long already. But I also have. Look, I just need the case in order so that as I proceed, that we're all operating on the same thing and that I have the authority to act regarding certain things. That's all I'm trying to do at the very beginning. And I'm not getting any answers that I don't.
Here's another fly in the ointment.
Oh, joy.
Yes, Joy, on Good Friday.
What is the other fly?
The other fly is that when I went to the property to put this notice for all persons living at 3270 North Maple Drive, Eric came out. I was on the outside of the house. I was going to tape it to the front window beside the door. It's a big window facing in. And Eric came through the door, rushing out the door. He grabbed the notice out of my hands and he pushed me physically with his entire body.
This did not happen. This is just, I can't understand.
Off the steps. I'm
going to object to this. This is not responsive to your Honor's request that council try to provide some sort of subject matter jurisdiction over a necessary party to the case.
A sheriff's
yourself a witness to this case.
A sheriff's report was filed, and the officers interrogated me. I filed a charge, and they also interrogated Mr. Cassidy at the house. That's what their report says. I feel like that's a reason that they say they weren't served.
Your Honor, I don't even know if that subsequent notice could even apply to the prior lawsuit. The complaint was filed before that subsequent notice was given.
It's a prior case. Well, I don't know who was on it.
It was Jerome, Alec, and Caroline Jerome, and Eric and Paula Cassidy.
I showed it was dismissed on December 8th.
Does it give a basis in there?
It does not.
Can I have that file brought down to me? Before we skip ahead, can I just ask, well, before we try to answer the beginning portions, just skip ahead. Is, folks, this really all about, you say they didn't pay money. They say they did.
No. Well, partially. Our position is that they withheld money on advice of council, previous council, because repairs weren't properly being made. They still don't have a working scope to this day, except for their was less. Not to mention raining that's dangerous and multiple other issues, Your Honor.
Got it.
We had an inspection by the Ann Arbor ordinance enforcement officer. And there were no violations, none.
There may or may not have been violations of any particular ordinances, but the lease has been violated because they haven't offered them an oven that works, a stove that works. The railing is
So that I'm clear, this property is located
30.
Darn. Okay. Well, no, I should have said darn, because if it was the city, then I could send this case away.
Yes. I started out in the city and they sent me to you.
I'm sure they did.
Yes, they did. They have that new system, which is very, very difficult.
Okay. Now this makes sense. The case was dismissed because it was dismissed because there was a 30-day notice that was sent. The case that was filed was a non-payment case.
I checked both boxes on it, both 30-day and 7-day non-payment on the, and I said to the judge, they were not mutually exclusive on the notice.
No, but yeah, there's a notice to recover possession of the premises for non-payment, right? I'm looking at the other file.
Mm-hmm.
The notice that was sent was basically a notice to recover property, basically a termination notice. That's why the case was dismissed.
It was as I read the statute, there's the 30-day and then there's the 7-day notice for non-payment that allows eviction. And I thought I don't see why they are mutually exclusive.
Okay. I now understand. I'm not here to give a lesson on it. I now understand why that case was dismissed.
Well,
The complaint and the notice served in that case did not correspond to each other.
the complaint was based on the notice.
Okay. Go get the two forms. Get the two,
okay.
No, just listen.
Yeah.
Because you argue with everything I say. Just go get the two forms. If you read the 7-day notice, which there is a 30-day box that you can check on this, on that recovering for non-payment of rent, the rights to the defendant are different. There is then a termination notice where the rights to the defendant are different than that, what the defendant can do. For example, the 30-day notice to terminate does not tell the tenant what they owe, because that's not the issue. The issue is recovering the premises. On the non-payment, it has to say what the landlord is claiming is owed.
Yes.
That's not what you filed in the last matter.
No. We had, yes, the judge looked at it and he said, have you paid the rent? He asked them specifically, and they said, yes, a payment was made. And then I said, no, a payment wasn't made because I had checked the account an hour before we went to court. They both, Paula's attorney and Mr. Cassidy, said we paid the rent. So they were dealing with non-payment of rent.
Okay.
And the judge was too.
I'm just going to rely upon the fact that I reviewed that file. I see why it was dismissed. I'm not going to, I'm not
okay.
going to argue with you about
well, I'm not arguing. I believe, I know everything you say, but what the operating principles in that hearing were non-payment of rent and the notice.
Your complaint that you filed was non-payment of rent. The notice that was sent was not a non-payment of rent notice.
Okay.
Therefore, Judge Barr properly dismissed the case because your notice did not match the complaint. So now that I have sorted that out so that I don't have to have any reference to the previous case because you kept coming back to the notice in that one. Now there's the notice in this case, but now you're saying there was a subsequent notice. Right?
Yes, and I didn't make that mistake again on this one. And I was prevented from providing what I consider to be proper notice by Mr. Cassidy.
You know what? Even if I assume, for the sake of argument, that everything you're saying is correct, I don't know. I'm not here to handle any criminal case.
Right.
But even if I assume that, I'm still not clear why you just didn't mail it.
I did mail it.
Then why were you there?
Because we've had issues about mailing and receiving. And Mr. Cassidy said that he had not been at the house for 3 months, so he wouldn't have gotten it.
Look, a notice doesn't necessarily require receipt. The notice says that you had to mail it, that you had to serve it on. If you served it in an envelope and they never opened the envelope, doesn't mean that you didn't even get served with the notice. I just don't understand why you were there. If you could serve the notice, you could mail the notice. Say I mailed the notice, you'd be saying it, there'd be something sworn indicating that you mailed it.
The officer that went with me to ascertain who the unknown people were living in the house advised me to come back and tape it on the door.
That's fine too. I just don't.
That's why I was there.
But you can just mail it.
I did.
But here's the problem. The problem that I have now is where we were an hour ago.
Okay.
I have notice on Eric. I do not have notice on Paula in my court file. That's my problem.
Would you be able to adjourn until, if they're asking to join her, then she would be willing to accept.
I'm sitting here looking at this. We got, oh dear.
We withdrew our offer to join her as a party.
Okay.
Okay. You know what? Just look closely at this, and I apologize. I was looking at the top of it. You've done the same thing. You've done the same thing as the December one.
I
have a
non-payment of rent. And my summons and complaint.
It's already in the docket. It's public record. I need a copy of that.
On my complaint, number 5, the plaintiff has a right to possession of the property for non-payment of rent. And I gave all of the rent that was due and in arrears.
Ma'am.
How does the complaint? Yes.
The notice that you sent, the one dated February 4th.
Yes, it says other non-payment of rent.
You got a copy of it in front of you, right?
Yes, right here.
Okay. Did you make me 2 copies? Could you please hand each party one of those?
Thank you.
Ma'am, you have your February 4th notice in front of you?
I do.
Look at the notice I just gave you.
Yes.
The notice is entitled, this is a scale form. At the very top. The first, the document you served at a notice was notice to quit to recover possession of property.
Mm-hmm.
You'll see that the proper document you should have been using is the demand for possession for non-payment of rent. You will also see what I was referring to earlier in that under those provisions, as you go down through the paragraphs, those paragraphs aren't contained on the notice that you sent. The reason they're not contained on the notice is because those rights don't apply to a tenant receiving that notice. But if you're suing them for non-payment of rent, the rights that are on that notice to quit apply to them. They have not been given notice for non-payment.
Right. I was going by number 2, you must move by February 13th or your landlord
and if
take
you
you to
were
court to
evicting
evict
them
you.
and there were no lease or there were justification under the lease to just take the tenancy, you could do that.
All right.
But you can't do it this way. Here's the problem. I don't have all the parties because I don't think their interest in the leasehold is divisible. First of all, legally, I don't think it's divisible. They're husband and wife. It's an indivisible interest. The leasehold. Just as if they bought a house. I can't divide it legally. That's the first thing. Second thing is, I don't have Paula on this case. So I don't know where we would even end up if we could proceed forward. But more fundamental to that, the notice that was sent, like the other case, is the wrong notice. Now, I almost hate saying this.
I'm turning you down a little bit.
Well, okay.
Okay.
You could amend your complaint to a termination of tenancy if you wish. But I don't know that, That's what you can do because that's the notice you sent.
Well, that would be my request, is to allow me, which Judge Barr did not, but allow me to
If I can,
correct things.
yeah. Here's the problem.
Okay.
I don't know that you can.
Oh,
Because even if you were to try to turn it into a termination case, you haven't given them enough notice.
really? All these notices to recover possession of property, they don't apply. Right? I get it.
Well, they won't apply because they can't be used in a non-payment case.
Got it.
That's the first thing. The second thing, even if you wanted to transform it into a termination case, because as I read the lease, rent is paid monthly, correct?
It has not been paid for many months, but yes, it's a 30-day
It's due under the lease monthly.
It's a period.
And you have to give them that same period in time as rent would normally and ordinarily be due. That means they would need 30 days. And instead, they got 4 to 13.9. So you could amend it. Ultimately, I'd have to dismiss it. But I have to tell you that you could amend it.
Okay.
I don't.
Okay. That's your ruling. That's the way it is. You.
So.
So they get to now do this the third time, not pay rent months at a time, not pay utilities, live in the house, have other people live in the house for more than 3 days without permission.
I'm presuming that is a hypothetical statement. Because if you're asking that the court is giving them permission to do that. No, it is the inadequacy of the filing
that is my
and the ability to do that, presuming that they're even doing that. I do not know because I have not heard the case. I didn't get past the procedural parts. Case is dismissed. Thank you.
Sorry.
Thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. He's going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.